This is a Section 21 notice that landlords can, but don't have to, serve on their tenants when they want to take back possession of their property. And it's one of the biggest and most avoidable bones of contention in the whole rental market. And in this video, the purpose of this video is to try and help landlords who need this help, which is not all of you, but some of you, and tenants understand how to avoid a complete nightmare for both of you by just getting this right. Now, first of all, let's just cover a couple of things because people start accusing me of being on one side or the other. I'm not on either side. I'm on the side of as many people as possible having a home, whether they rent it or buy it. Don't care. And it is true that most tenants are happy in their home, right? Which means they have a good landlord. A happy tenant equals a good landlord. And that is the majority of them. And good landlords, professional landlords who understand that they're running a service business, it's not an investment, it is a service business, and understand the realities of how the rental market works with tenants coming and going. You don't need to watch this. You guys already know this, and you guys are reliably providing a lot of people with long-term secure homes without ever needing to go to court. The problem comes when you get naive first-time landlords who don't bother to do their very basic research and understanding the risks and the pros and the cons of what they're getting into. It's a bit like people believing the house prices always go up. People believing, oh, landlord can't go wrong, easy money. And the number of landlords who find out the hard way that actually, if you don't take it seriously and you don't know what you're doing, it can go very badly wrong and blow up in your face. I am not on either side. Don't accuse me. I don't want any angry tenants or angry landlords complaining. I am on the side of both of you being better off. So tenants having a better tenancy for longer and not being evicted by being blindsided, and landlords who are good landlords having a successful journey as a landlord. I'm on both sides because without both of you, it doesn't work, does it? It really, really screws up a lot of people's heads that they can't understand that I'm not on one side or the other because that doesn't make sense, right? If you're a tenant, you need a landlord. There's no point punching landlords in the face. And if you're a landlord, you need tenants. Likewise, you need each other. Now, the problem here the root of the problem is a complete lack of understanding of the basic legal process. And you don't need to be a lawyer or an expert to understand this. These are just basics. And below, by the way, I've put two links. I put a link for landlords to the independent landlord's website. And this is Suzanne Smith. She's a lawyer turned landlord. Let me just show you, put it on screen. The link is there below for her website. It's a absolutely superb. She's easily the best source of professional, easy to understand information for landlords. And if you are already a new landlord and you haven't done your homework, go and check it out. And if you're a landlord having a bit of a pickle, go and look at her website. She's amazing. There's no commercial relationship there. I'm recommending this because I think it is the best resource for landlords who want to understand what's going on. She's not trying to sell you anything. She's trying to help make the rental marketplace better. And as a former lawyer, she also knows her stuff, and she's a hands-on landlord herself. And I've also put a link for tenants that just covers the three basic things that you need to know as tenants. And that's in the description below. But let's just put the law to one side for a minute, okay? And again, without saying whether I agree or disagree, and without being on anyone's side, the situation in life is that we all need to move home sometimes. And the situation for landlords is that sometimes landlords who've been landlords even for a very long time, for legitimate reasons, need to get their property back. Both of those two things should be easily doable without a problem. The problems arise because, in my view, the notice periods required on both sides are too short. Okay, the legal statutory notice periods required by landlords to evict tenants and the tenants who want to serve notice on the landlord are both too short. And this is the root of many, many avoidable problems. Okay, because it's such a deep rabbit hole. I once got the most amazing piece of advice from someone. It was the best piece of legal advice I ever heard. And it's applied to me so many times throughout my life. This is like 35 years ago. And this person who'd started a company with 3 people, built it up and sold it for $200 million, British guy, British company, sold it to the Americans back in the 90s, early 2000s, had more experience of legal problems through business and everything else. And he just said, when you go into business with somebody, when you sign a contract with somebody, you're either signing a contract with someone who's a reasonable person, and as things arise that are problematic, you'll be able to talk to them and sort them out. Or you'll be going into business with someone who can't do that, won't do that, and no contract you sign is ever going to keep you out of court. It's just you're going to end up in court. So basically, what he's saying is either deal with reasonable people or you're going to end up in court. And there are no other ends to that story, okay? Because in almost all arrangements, contracts, whatever, situations arise, unexpected situations arise. And this is where the problem comes. So, first of all, I'm not a lawyer. This is just my own opinion. This isn't any advice for anyone that didn't already understand. This is not advice. This is just my opinion on the matter, okay? This Section 21 notice is just a procedural step. Now, what do I mean by that? A lot of tenants, when they receive this, understandably, because they don't understand the process, go into a flat spin and panic and go, oh my God, we're going to be homeless. And maybe they will be. But this does not mean that you have to be out within the 2 months. And this is what a lot of tenants and landlords, the really naive landlords, are unaware of. Okay. What the law says is that if you are a landlord and if you must evict through the courts your tenant, then this is the first step in the process. Right? Let me read what it says. Notice requiring possession. Right? This is not an eviction notice. Notice requiring possession of a property in England let on an assured short tenancy. Form number 6A, Housing Act 1988, Section 21. Information for the tenant. This notice tells you that your landlord requires possession of your home. Right? Doesn't mean he gets it. It just means the landlord requires it. The landlord would like to take the property back. It doesn't say here that you've got no choice and you have to be out. And that's what a lot of tenants assume, that this means I've got no choice and I must be out. And they assume that if they don't get out, terrible things are going to happen immediately. That's not the case. So the notice tells you that your landlord requires possession of your home. It just says the landlord wants their property back. Now, landlords, if you want your property back, my very strong recommendation to you is that you don't blindside your tenants with this as a first step. That is a foolish and unwise thing to do because it immediately puts them on the defensive. And because you start the process by pulling a legal trigger by serving this notice, which, by the way, most of you don't serve correctly. Most of you don't actually go through the checks. What must be in place for a Section 21 notice to be accepted by the court when you apply for your eviction notice, right? Most of you get it wrong. There is a long list of things you must have done correctly from the very start of your tenancy. And if you cut any corners, this doesn't help you and it won't get accepted by the court. All right? This is why, like, I don't know if any of you ride motorbikes. I've got a motorbike license. And do you remember that there's something called the CBT, the compulsory basic training? It's the thing that the government requires you to do before you can ride a small motorbike up to 125cc on public roads. It's not a test. It's not an exam. It's just compulsory basic training. And if you just turn up, complete the course, you got your CBT. That is exactly what landlords should have to do. Just a half a day thing that basically where the person literally now goes, are you aware of the risks of being a landlord? And are you aware of the obligations? And are you aware of the consequences? And if landlords did that before becoming a landlord for the first time, half of them would go, no thanks. I'll pass, thank you very much. But CBT, this compulsory basic training, would avoid so many issues. Right. So landlords, first of all, don't start by serving this, right? Give your tenants what you would want if you were a tenant, which is as much advance notice as possible of the fact that you'd like it. So for example, say, this time next year, we're hoping to have sold the house. We're going to be putting on the market in 3 months' time and expect it to take around about 6 months. So how do you want to play it? And some tenants will go, well, actually, that's cool to know, but what we'll do is we'll move out a bit sooner rather than later. There's no panic. We've got time. We'll move out sooner rather than later to just give you a clear path to sell your house. But anyway, the tenants are always going to appreciate advance notice because it gives them options. Because being forced to move house at a bad time for your kids, for school, for work, for family, for illness, it's a nightmare. And so with enough notice, you can absorb it, right? With enough notice, your tenants can absorb it and they can move house. And none of this is necessary. They'll just go of their own free will. Now, the next line says, you should read it carefully and seek advice about your circumstances as quickly as possible. Yes, true. You, the tenant, are entitled to at least 2 months' notice. At least 2 months' notice, right? Before being required to give up possession of your home. In some circumstances, a longer notice period may be required. So depending on your circumstances as a tenant, you might be entitled to a longer notice period. If you do not leave your home, so this is the key part I want tenants to understand, and landlords who don't get it to understand, because this is where everyone gets it wrong. If you do not leave your home by the date given in section 2, your landlord may apply to the court for an order under section 21 of the Housing Act 1988 requiring you to give up possession. Okay? So this is not a court order. This is just a legal notice informing you the landlord's intention. And this is not an order under section 21 of the Housing Act requiring you to give up possession. Okay, so this is not yet a court order saying, you, the tenant, we are the court, and we, the court, hereby order that you, the tenant, must give up possession of the property. This isn't that. That has to come as a court order, and it is a next step in the process. Even that is not an eviction order. It is a precursor to an eviction order. And even if there is a court order from under section 21 requiring possession, or a possession order as they're known, right? You still don't have to get out until they do an eviction order, which is yet another process. And it costs the landlords time and money to apply to the court for this. And if the landlord applies to the court for an order under section 21 requiring you to give up possession, they must have ticked all the boxes perfectly in the process. And if they haven't, the court will not grant them their possession order. So there's a possession order and there's an eviction order. And the landlord must get both before they can legally evict you. It is a long, painful road for a landlord to evict a tenant who doesn't want to get out, right? And again, I'm not saying that's good or bad. I'm just saying that is the current situation. It is a long, painful, expensive road for a landlord to evict a tenant. Okay. And it goes on and gives various things about you've got advice, you can do this. Now, this is the really key thing as a tenant. I put this on X yesterday, right? If you believe you are at risk of homelessness as a result of receiving this notice, you should contact your local authority for support. And that is absolutely right. And you must do that, right? And this is important because a lot of people, a lot of tenants in this situation make this fatal mistake of thinking that they have to get out, and then they get out and then they go to the council for housing support. And if you do that, the council will determine that you are intentionally homeless. Now, that sounds like a what? It's a legal term. What it means is because you voluntarily gave up possession of a property before a court had required you to do so, before a court order giving an eviction notice had happened, you voluntarily gave up accommodation that you were legally entitled to remain in. And therefore, the council can say, sorry, because you did that, we don't have to find you a home now. And most tenants who end up in the situation are unaware of that. Must, you must remain in place until you are actually evicted by bailiffs with a court order if you want to get housing support, right? I know it sounds weird, but you must. And by the way, if your landlord gets intimidating or harassing or anything, they are committing an offence. And it's to do with it's Prevention of Eviction of 1977 or something like that. I can't remember. Where making you feel uncomfortable in the home is an offence, and it can affect their chances of evicting you. And if you think this applies to you, by the way, go and look it up. Just go look it up. Just go and search. My landlord's making me feel uncomfortable. They're trying to intimidate me to get out. You can report the landlord for doing that. You've got to have evidence of it. You've got to have either a copy of the text or an email or whatever, which is making you feel like you're being harassed. And you make a report. Go online and make a report of it with your evidence, because that will. It's not that I'm saying you should be trying to get yourself more time in the property, but it will make the landlord back off, because all of us need to be able to live in peace in our home that we're legally entitled to occupy, to go to work, to look after our families, and to have time to find another home. And if the landlord's hassling you, it makes all of that even harder. I mean, any landlord that does that is demonstrably a fucking idiot, right? Because you're literally making it even harder for the tenant to do what you want, which is to leave. Okay? So if you're a landlord and you don't want to end up in a lengthy court process, don't do this until your tenant has expressed refusal to move, right? Of course, if your tenant expresses refusal to move or reluctance to move or isn't moving when they said they would, of course do this. But you've got a much better chance of a tenant cooperating voluntarily if you just talk to them. So anyone affected by this, I mean, if you're thinking of being a landlord, go and go to AI and put in the question, what are the risks of being a landlord? Just start there. Okay. What are the risks of being a landlord? How likely are they? How often does it happen? Because this is the other thing. A lot of landlords are aware of the risks, but begin being a landlord thinking, oh, that will happen to me. New landlords don't think about void periods. And by the way, if having a void period in your tenanted property for more than a month would cause you a problem, a cash flow problem, you shouldn't be a landlord, right? Because you've got to be able to, like, in the scenario where the tenant can't afford to pay their rent, and this is the point, right? It isn't necessarily tenants being deliberately evasive or obstructive. There are people, good, hardworking, honest, decent people who are tenants who are losing their jobs now on a daily basis and are finding themselves in a position where they simply cannot pay their rent. Okay. They still need somewhere to live. Their options, the law now says that they can stay in place until you get an eviction order. And in that scenario, as a landlord, you've got to decide, well, do I want to be patient and give this tenant time to find a new job? What are their prospects? Because that might actually be a less expensive thing than starting the legal process that with court backlogs might take, I mean, in some cases, it's a year, 18 months. And the number of landlords that start that process go, right, I'm going to evict you. Get out. I'm going to evict you. And 18 months later, look back and go, I wish I'd just come to a reasonable agreement with them. Go, listen, what's fair? What do you need? How long do you need to get out? Just avoid the legal process is the last resort, right? The other thing I've seen happen is good landlords. They were accidental landlords. They were living in a home. They got posted overseas. It was a great job opportunity from their existing employer. Said, "Do you want to go and have a 2-3 year post overseas?" And they, yeah, we'd love to do that. And so they rented their home out for that reason, right? Not because they're being greedy, nothing else. They just needed someone living in their home while they're away. Um, they still got a mortgage to pay, etc. So they very wisely went, well, we don't really know what we're doing, so we'll go to an agent. And they went to an agent and they paid the agent full management fees to manage the property for them while they were abroad. And this agent, this letting agent, was a really well-known, high-profile, quality brand who left these landlords in an absolute nightmare with people in their home treating it badly, wouldn't get out, causing nightmare, causing legal problems, and the agents did nothing. So you really want to choose if you're allowed in that situation where you're thinking about going abroad. You're not being a landlord for an investment purpose. You're not being a landlord to be professionally. You've been posted abroad. Maybe you're in the military and you get posted abroad overseas and you want someone to rent your house out for a couple of years. Choose your agent really, really carefully. Make sure you get a good one. Don't just think any old agent's going to do it okay, because they're not. And also don't think that the legal process is going to help you and protect you from horrors. There are tens of thousands of landlords around the country who followed the legal process to the letter and have still had absolute nightmares. And if you don't, by the way, if you do end up in a legal situation and you don't follow the legal process properly, a bad situation where you've got a dishonest, disingenuous, badly behaved tenant, if they understand the legal process better than you and you're a landlord, it can end up even worse for you, because you sue them, they countersue you. And I've seen it go horribly wrong for a landlord. I personally know of a landlord in London who moved abroad. His home he'd always owned, he lived in it, was his own home for a long time, owned it from decades ago, moved abroad, had a tenant move in, everything was fine, tenant was fine, a couple of years was fine. Tenant lost their job, couldn't pay. Landlord was very accommodating. Look, don't worry, take your time, get a job, everything fine, didn't go legal. But eventually it went on too long, and eventually the landlord realized, hang on a second, this person is now exploiting the situation. They do have work, they're not paying their rent. And he went legal, but he didn't do it properly. And the tenant turned around and ended up getting a claim against the landlord for over £100,000, simply because the tenant followed the legal process properly. The landlord didn't. The landlord had to remortgage his mortgage-free home to pay the tenant off. That's how bad it can go if you're not careful, right? And so many naive landlords end up in this situation. They don't tell anyone, do they? Because you feel really, really foolish, but it can go so horribly wrong. Oh, wow. Okay, some good comments coming here. Boss Hog says, that is my situation, Charlie. I've moved abroad and renting my house in the UK out. Agreed about the letting agent. Don't be swayed by an agent who gives the highest rental. Where have we heard that story before? Just looking for any other comments on here. Good morning, everyone. Roy, Lucas, Jack. Hi, guys. That's it. I wanted to put this out there. If you know anyone, a tenant or a landlord that's in this situation, forward this video to them, and maybe there's the links below. If it's a landlord, send them to the independent landlord below. But just talk. And the problem is that so many landlords and tenants it's an awkward situation and everyone feels defensive. So the conversation feels like it's going to go badly wrong. But I promise you that uncomfortable, awkward conversation, when you just talk it out and work out what's best, the best way forward for both of you, amicably and non-legally, without compromising your legal rights, you can just say, okay, look, what works for you, what works for me, and just do it on an informal, cooperative basis. Okay, everyone's got struggles at the moment, and if you think that your struggles are worse than their struggles, That's step one down a bad road where it ends really, really badly. Never think your struggles are worse than someone else's. Always assume the other person's got struggles too. You've both got struggles, family struggles, money struggles, work struggles, whatever it might be. Just don't automatically go, well, that's not my problem. You have to do this. Because if as a landlord, you turn around to your tenant and go, oh, don't care. That's not my problem. You can do this. Then what you're doing is you're forcing your tenant to go the same. Well, okay, you just made my problem worse now. Now I, as the tenant, who was a reasonable person that wanted to just do something reasonably, you've now forced me to use the full extent of the law to defend my position. So now I'm not going anywhere till you get an eviction notice, which means you're going to have to apply for a Section 21 possession order, which is not that. That's just a notice, right? You've got to go. The landlord's got to go to court to get the Section 21 possession order. And if the landlord hasn't done everything perfectly from day one of the tenancy, then they won't get the Section 21 possession order. And this is another thing that so many landlords get wrong. After that, they've then got to serve that possession order on the tenant with a date. And if the tenant doesn't get out by that date, at that point, then the landlord can apply to the court for an eviction order. The process takes forever. And if you're a landlord and you're highly leveraged, you're probably going to end up in default on your mortgage before you've got your tenant out. It just all comes crashing down around your ears. Okay. Now, if you've got an unreasonable tenant, if you've got someone that you know is just an unreasonable, disingenuous, dishonest nightmare, first of all, try and avoid those tenants in the first place. But secondly, start this process without delay. If talking is not going to get you anywhere, start this process without delay and use haste, not speed. Double check the requirements of the Section 21 possession order before you begin the process to make certain you've got your ducks in a row. Otherwise, your possession order will be refused by the court. Toby says, I'm unable now to let out my London flat. It's simply not worth the risk. Correct. I agree with you. That's why I've been saying for a long time that I think what I call retail buy-to-let, where someone just has one buy-to-let property as an investment, is no longer viable. The risks are too high. Yeah, this is a situation. You can get bad tenants and bad landlords. On the majority, most tenants are okay and most landlords are okay. Most tenants are happy, most landlords are good. We only hear about the bad ones, but the bad ones are a nightmare in every situation. Bad tenants and bad landlords. Anyway, guys, I must go. There are links below again to the Independent Landlords website and blog, and also a link. I've put a link to just a post I did, which just gives the 3 things as a tenant you need to know. Right? Don't sign contracts like tenancy agreements without checking them. I mean, honestly, as a tenant, read your whole tenancy agreement before you sign it. Okay. Say to the agent, look, can I please have 24 hours to make sure I can read, understand this and get some, you just got to make sure you understand it, because it's not that you can change the tenancy agreement. The tenancy agreement is put there by the landlord, but you can ask, right? So you have 2 options. You read a tenancy agreement. If the risks as a tenant you feel are unacceptable, then you have the choice to walk away and decide not to rent it. You may lose some of your costs up to that point, but secondly, if there are clauses in there that you don't like, you can just ask to change that clause. Say, look, can we, where it says 6 months there, can we make it 3 months? Or where it says this, can we make it that? And as long as it doesn't contravene any of the statutory requirements, there are many, many different versions of an AST tenancy agreement, and it's all up for discussion. So remember that too.